I'm ready.
Okay, so we've got two main issues. One is the deposition transcript designation, and the next is these two witnesses who are being contested. So, let's start with the depositions. I'm going to start with the short version, I guess, which was confidential. This is the deposition of Courtney Jones, confidential. I have to say again, folks, if you could see what I'm looking at here, it at times was hard to understand what objections are being made where, what's been crossed out, what's in pencil. Looks like star designation for some things but not others. It's just hard for me to make the determination. So, I'm not sure what kind of a record is created about what objections were made. The best I can do, and I was reading these last night after our annual Judges Night, the best I can do is make my rulings and then give you the opportunity to contest them. I'll say that the objections on 138 are particularly difficult for me to see what objections are being made. The first question is, at the top is an email that you sent to Britt Truong, correct? I think that question's okay. And then there's a series of questions, and it seems that the objections are 403 and designation. I will tell you my particular difficulty in getting my arms around designation in the time frame involved. If I had a lot of time, I could fully appreciate all that was designated and then consider cross designations, but I'll tell you I'm very, very loosely interpreting the designation issue. In other words, I'm very hesitant about reducing what might be designated under the notion that it's beyond the other designation. So that objection isn't going very far, and I do think the broad issues addressed on page 138 are within the previous designation. I think 403 is a tough objection for me to even understand when you're asking someone about this email concerning the names of products. I just don't understand a 403.
John, I think I can help you out here. This came into evidence yesterday, too, and there was testimony about it. We'll withdraw this objection.
Okay, good. So that was my that's when I first opened this up. Now, turning to page 147, and again, there may be objections in the middle. And if I don't mention them, it means they're overruled. Let me make that statement. If I don't mention something, it means it's overruled. Now, what is going on page 147? And you see mine has stamps with pencils kind of going through some of the objections, but I can't quite be sure what objections they go through. It does look like it says keep speculation. So, 147, I'm going to show you two documents. Have you seen them before? Answer yes. That's okay. What is Exhibit 29? This is the same as the other. It was a link to the ingredients, but this one was for the Mixed Chicks conditioner. If there's an objection to that, it's overruled. Next question, and this is an email you sent to Britt Truong on April 20th, 2010. Answer correct. Objections overruled. Okay, then I turn to page 153. And line, again, there's a number of confusing crossed out or not crossed out or exclamation pointed, maybe partly erased. Again, it's hard for me to say. But when I see, do you know why Britt said that to Dawn? Line 8. Answer. She wanted to let our artists know the inspiration for the product. I'm inclined to sustain that, and obviously I'd add that that might be a more significant piece of testimony than some of the others I'm struggling with here. So my ruling would be to sustain pages, lines 8 through 10. But let me ask this, what is the position of the parties concerning the frequent lack of any objection in these transcripts? Does that waive the objections?
I think on that one it does, Your Honor.
No, I'm talking about in general. Don't focus on that one. I'm talking about in general.
Objections as to form or as to questions that could be cured at the deposition, I think it is a waiver. And foundation could be cured.
Tell me what your view on what objections are waived.
Well, I know this is a gray area. I think
gray area. That's why I'm asking.
It's a foundation objection, and I saw the clock, so I'll be brief. It's a foundation objection, and foundations can only be cured. Foundation issues can only be cured at the deposition, and so it's more of an objection on the objection to form side than something like a hearsay.
What do you mean? It's more of an objection as to form side.
Well, we all know that if you're looking at the black letter,
which is what, who is what, how. I don't know what you're what you're referring to when you say that.
Okay, an objection as to form would be something like objection leading or objection compound, questions that could be cured on the spot in the deposition. And a lack of foundation objection can be cured at the deposition, and that's why I think foundation objections are waived if they're not made at deposition.
Okay. All right, let's take this one. I wanted to list all of my rulings, but we'll take this one up right now. Anything else you want to say as to this one?
No, Your Honor, and I think my clock is still running.
Well, see, now this is an issue. You know, it occurred to me that if you want transcripts introduced, and you have me reading them for 2 hours late last night, it occurred to me, maybe devilishly, I thought, I should be running the clock. I didn't run the clock last night. I do think here, these are arguments of counsel for your testimony, and so though I didn't run it last night, I do think in open court when we're arguing things, perhaps it should be run, but it's not running now. And if it would be running, it'd be running against the defense, because I'm going to ask them, what is your position as to the failure to object on this one?
Well, Your Honor, this is the sort of question that I think you can't, you don't know exactly what's going to come out, what's going to be used. I think in terms of the form of the question, this is one that does call for speculation, and I think there ought to be a waiver on that kind of thing when evidence is trying to be used much later at a trial. I think the rules of evidence ought to apply to the introduction of evidence at the trial.
Well, see, it's not only speculation. I mean, the problem is if the follow-up foundation question was asked, it's likely to be, what is it likely to be? It's likely to be, she told me, which sort of suggests to me another possible objection, right? That's an argument on your behalf.
I think that's right.
Yeah, I don't know how this question could be cured. Do you know why she did something?
Oh, yeah. That's how it could be cured. Do you know why she did something? I mean, and the cure would most likely be with hearsay. She told me that. The cure could be some non-hearsay. It could be a spontaneous declaration that, oh my gosh, that would overcome a hearsay objection. But there's ways to cure foundation. How did she know? And the reason we have foundational objections is so we can find out if it was based on hearsay or some other thing. So, I'm sticking with my ruling. Let lines 8 through 10 are sustained. Now I'm going to move to the broader volume.
And Your Honor, when you do that, can I might be able to help you out. There's some designations I saw last night that I did not understand that we had made that I will withdraw.
Well, now I need to, I've got all these blue tabs. We just need to go through these blue tabs, and if I identify one and you withdraw it, you let me know. I might have just passed over it. So I'm now on page 46.
And I'm withdrawing 46-1 to 14 and 46-19 to 47-23.
Good, okay. Great. Thank you for that. And I appreciate the time that you found to put that in. That's hard to do. All right, now on 52, I'm looking at blue designations on 52 with green objections, and I'm inclined to sustain the question at line 9, the question at line 12, the question at line 15, and the question at line 20, and the question at line 24. The opening question, and when did you first communicate with anyone at Sally Beauty regarding mixed chicks? That would be fine, but then what did he say? When did the conversation take place? So, bottom line, 9 through 25 sustained, and let's address it now to avoid confusion.
Mr. Honor, and this may be brief. This is, I believe those are party admissions. I believe those are two individuals at Sally Beauty in the course of their ordinary business discussing things within the scope of their authority at the company, and they are employees of the defendant. But I think we talked about this yesterday, so I won't belabor it.
Well, we didn't. Let's see. You need to remind me, have I made a ruling as to whether Courtney Jones is sufficiently high on the ladder or is making statements that are subject to the admission standard?
Your Honor, I do not believe you've ruled on that, Your Honor. But
what is Courtney Jones?
Your Honor, she is Associate Brand Manager underneath Ms. Truong, also with reporting lines to Ms. Reynolds and Ms. Walker. Your Honor, the standard for whether I could play someone's deposition, and by the way, Ms. Jones' deposition is being played because she's not available. The standard for playing a deposition, which Your Honor looked at with Ms. Reynolds, and the standard for party admission under the hearsay rules are different. A party admission under the hearsay rules involves any agent who is speaking about something within their authority. And so it could be a driver talking about his route, and that would be admissible under the party admission hearsay exception. So it's different standards, Your Honor, but that's all I have to say about it. And Your Honor did rule on it yesterday, and I would like to reserve the right, once I get a chance to question Mr. Carcieri next week about his scope of authority, to try to reintroduce them.
Lines 9 through 25 on page 52, sustained. Then, page 59. Did Norrie ever express to you that he was interested in purchasing the Mixed Chicks company? Consistent with my previous ruling, that would be sustained. I softened it up when it seemed to be a direct offer, because an offer isn't offered to prove the truth. It's offered it's offered for reasons other than proving the truth. This seems to be offered to prove the truth. So, the objections identified on 59 are sustained. Then I'm turning to 73. Now, along the way, Mr. Stewart, maybe you withdrew them or whatever. I read them and decided not to sustain. So
Your Honor, there is one more along the way that I've represented to counsel for the plaintiff last night. I would withdraw.
Well, but I'm saying you don't have to withdraw if I'm not stopping on that page. Stopping on pages where I have a question or where I am sustaining. So if I passed over a page, it means I did not sustain, so it's moot.
Okay, but just for purposes of the videos, there is another issue at play, and just to Mr. Parker and Mr. Wexler, 65, 16 to 22, we've agreed to withdraw.
Okay. All right, now I'm on page 73. And by the way, again, I hate to say this, folks, but when I tell a jury to be here at 8, we got to start at 8. I don't want to get 8 people here and have them get here at 8 and then wait. So we've got 15 more minutes here. Let's see what we're doing. We're now on page 73, line 5. My ruling was to sustain, but have any of those conversations touched on why she selected yellow as the color for the product? And hearsay is one of the objections remaining, and I would grant that on hearsay. And I think actually for efficiency, you need to address that now if you want to address it. Anybody want to address it? And I have to say, folks, I hate to say this, as I go through this and I'm going back and forth, I'm not sure who that ruling hurts, because I'm going through this so quickly. So I'm not sure who wants to speak up, but it's sustained.
I think that was our designation, and don't.
Okay, good. Then at the bottom it says, beginning at the bottom, in those conversations, blah, 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 did she give any other reasons? Again, I'd sustain that on hearsay at the bottom. That's my ruling.
No argument.
Okay, then on page 84, the first question, did Truong ever have any discussions with you? Yes. What did she say? I'm sustaining that. So that would be page 84, lines 7 through 13.
And Your Honor, our position on that is the same as the other hearsay objections, so Your Honor stated your reasons. I don't want to belabor it, but we wouldn't argue that further if it were not taking too much of your time.
Okay, page 86, lines 16 through 22, sustained on hearsay. Page 93, 16 through 21, sustained on hearsay. Have you ever heard anyone suggest? Now, I must say that's pretty significant testimony. I guess we got two things. What's the validity of the objection and the ruling, but what's the importance of the testimony? Strikes me as pretty important testimony, but I am sustaining the objection. I've got two more, and then we'll have more time for you to argue. Page 94, question, where have you heard that from? Answer, on various forums on websites. I'm sustaining that. Oh, let me go back to 93.
Sorry, Your Honor.
Hold on, let's go back to page 93. Line 16. Have you ever heard anyone suggest? That is sustained. Lines 16 through 21 on page 93. Then at the bottom of 93, where have you heard that? On various forms of websites. Well, it's sustained, but it won't make much sense anyway, given that I sustained the previous antecedent question. And then, line 3, have you ever heard that suggested from anyone at Sally Beauty? Answer, no. I'm sustaining that. And then the next question, has anyone within Sally Beauty commented on the fact? That would be sustained. And then line 13, have they commented on the fact that, so that would be sustained. So summing up, and our poor videographers here, I can now say that I'm sustaining from page 93, line 16, to page 94, line 17. I'm sustaining that. And then I have one more, and then you can come back and argue. And that is on page 131. And I'm sustaining that whole thing. It's line 8 through 23. And it's a question, have you heard anybody at Sally Beauty, even if they didn't tell you, have you heard of any discussions? So that's all sustained on hearsay. So that'd be page 131, lines 8 through 23. So those are all my rulings. Let me know if my page references were unclear. I'm particular, yes, sir, because I don't think I was clear enough for you as I went through, because sometimes I was speaking generally. Let's go to the man that counts.
I didn't get an ending line at 5918 through line...
59, good for you. Yeah, I may not have done that right. Okay, 5918 to 5924. Now, I will say that I don't see any objection to what's on the next page, so I didn't rule on it. I'm only ruling on 5918 through 24. Let me ask any more questions from the videographer, because he's got the work to do. Okay, anything? All right. Then I'll turn to the attorneys and ask what they are saying here?
Page 131, line 8.
I'm sorry to interrupt, Your Honor. Can I go back to that last one, because there was a carriover from 59 onto the top of page.
Not at all. Look at the green stamp. It says, hearsay, 59:18 through 24. So I stopped.
You're right, Your Honor. It does say that. I apologize. I didn't see that.
Yeah, I know, and that's...
You're right.
Your Honor, 131, 8 through 23 goes to state of mind and is relevant to intent.
State of mind of who?
Ms. Strong, not just this, the state of mind here is relevant for not just the decision to sell the product, but to keep selling it after the sale.
Now, how does Ms. Truong come into play on state of mind here?
Well,
This is Ms. Jones.
oh, excuse me, it goes to Ms. Jones' state of mind.
State of mind is of the declarant, isn't it? Help me out here. You know, people confuse state of mind and intent, and I think you're moving from state of mind
Right.
to intent, maybe?
Right.
I don't mean to be technical, I'm just trying to understand. So
You're absolutely
they
right.
get confused, but intent kind of is state of mind.
Its effect on the hearer, Your
Okay,
Honor.
effect on the hearer. So
Right.
then you're saying it's effect on Ms. Jones, so let's take a look here. Hold on. Okay, now, you know, that's such a broad thing, intent to the hearer. It is potentially a gaping hole. So I ask, why is the intent of the hearer relevant? Otherwise, the exception gobbles up the rule. Why is the intent of the hearer here relevant?
Well, this is a case involving willfulness and also punitive damages involving conscious disregard, and someone who's put on notice that in the marketplace is perceived as a knockoff and then continues to proceed to sell it. That's relevant to show that they continue to act in conscious disregard, Your Honor.
That was a winning argument for you a day or two ago. Do you recall that?
I do.
Okay, so what about that?
Your Honor, I disagree with that.
Let me just to sum up, excuse me for interrupting, just to sum up. It's not offered for the truth that it's a knockoff. It's offered for the fact that Ms. Jones had information where someone thought it was a knockoff, whether or not that was true or not. And so that's what we're looking at. Why is that not relevant? But, I mean, why is that not overcoming a hearsay objection because it's not offered for the truth?
It's offered for the truth that somebody said that, and so it is just
Okay,
classic.
but the witness here has personal knowledge that someone said that.
But what she's saying is just in general, she's heard some things like this. She's not giving specific testimony on it. And a knockoff, that doesn't mean, that's not intent to infringe. You can use the term knockoff and have it be completely innocent. A compared to product could be referred to as a knockoff. This is also more prejudicial than probative in that there's no definition given here in this passage as to what she understood those people meant. And a ripoff, you know, these are pejorative terms that are not appropriately explored in the deposition, so to give appropriate context to this quote.
Anything further on that?
The latter half of that was a 403 argument that wasn't put in the transcript.
It is, Your Honor.
Oh, it's 403 there, absolutely.
Yes.
And circled.
Knockoff must mean something that everybody understands, Your Honor, because it drew an objection yesterday as a pejorative term, and quite frankly, it goes to intent.
Okay, I'm going to overrule the objection on 131. Everyone got that? All right, now let's turn to the two witnesses. And I'm looking at the trial brief. Yes, sure. No, please, go ahead. No, I don't want to go. This is important. We're doing what else?
I did have one. It's on page 147, so this is in the confidential portion.
Okay.
Our objection was an authenticity objection as to Exhibit 30. What the witness says on the top of 148, she was asked, and then Exhibit 30, is that what was displayed on the link that you sent to Britt? Looks like, I guess. And she's just speculating. She doesn't properly authenticate it. And then below, she's asked again that question again, and she just said, I just recalled that it was the ingredient listing, but she doesn't specifically authenticate that document she was handed.
tell me what question you're specifically objecting to. It's a little hard because it flops over to the second page, and the second page doesn't have an objection, but if you look at the very small print on page 147, it does say to 148, well, to be honest, yeah, very confusing what it's saying here to me.
Well, the
But in any event, I will allow you to address an objection to what's on page 148. There's a little ambiguity on the previous page as to what's objected to, but I didn't talk about 148. Let's talk about it.
Yeah, the intent here is the authentication is to Exhibit 30 is one of the objections, and Exhibit 30 gets talked about on the next page, but she doesn't have a specific recollection that she testifies to about this website. She says,
So I remember reading that last night. So, and then Exhibit 30, is that what was displayed on the link that you sent to Britt? Now, let me also just say, you know, I'm reading this last night, and I don't necessarily have Exhibit 130 in my possession, and I don't know that if I did, it would be the same 130 addressed in the deposition. So it's important we go over this now so I have clarity. Tell me what Exhibit 30 is. Is that something from Ms. Jones?
It is not, Your Honor. There was an email with a link to a third-party website. The plaintiff printed out that. It is trial Exhibit number 30 also. We kept the same exhibit numbers.
Good for you.
It's a third-party website, a B Glowing website.
A what?
B Glowing, the letter B Glowing, I believe is the name of the website.
Okay, so 30 is the same. All right, now that makes more sense. I thought it was the emails that actually had a couple of links where you went to get model pictures or whatever. So now, with that clarification, that may change things. Let me look. I'm now inclined to sustain the objection. You know, I thought it was the link that the writer put into certain websites that we saw yesterday. This is different, and I think there's an authentication issue. So I'm inclined to sustain page 148, lines 1 through 17. Response?
We submit, Your Honor.
Okay, that'll be sustained. Now, thank you, and let's go to the witnesses. And let me review the bidding here. The plaintiff wants to call 2 witnesses, and at this point, when are they going to be called? When will we have time to argue this, because we're coming up on our 8 o'clock hour?
No, they should be here at 10 a.m.
Okay. So that means we could further address this at the break. At this point, I would like Mr. Stewart to specifically tell me what your objections are. And I'm going to hold you to this so I'll know what's in the ballpark. Because I've read papers. I read something that was just filed 35 minutes ago, I think, from the plaintiff, I guess. What are your objections?
I'm actually going to have Mr. Lee address this.
Very good. Mr. Lee.
Yes, Your Honor, we have 402, 403 objections to both witnesses. These witnesses we submit, and it's in our trial brief.
You're limiting yourself to 402 and 403? Just want to make sure, so I know what I'm doing.
Hearsay objection on a Google link, Your Honor.
Yes, sir.
Hearsay on Google. What else? Okay, I got it. Just want to make sure. You know, the brief was written a while ago as part of a trial brief. We've now been in trial. I'm always the one that says the evidence is best, usually in response to motions in limine, it's best viewed in the context of what's coming in. So, having heard everything, I'm just wondering if there's anything else. And you know, if it's not in the brief, that's okay. I just want to make sure I got them all down so I can rule on it.
It's in the brief, Your Honor.
No. I'm saying if you have an objection that you couldn't foresee to put in the brief 3, 4, 5, however many weeks ago, I just want to get it down. And so I've got 402, 403, hearsay on Google. Anything else? And then I'll just look at it. I'm just giving you a chance.
Yes, sir. I don't believe so.
I've read your brief. They gave me something as of last night. Okay. So I'll review it in that context. So
we don't dispute the hearsay is irrelevant. We're not going to introduce that hearsay evidence, so that's off the table. We're not going to look at that.
Okay, so I got the 403, and your brief was well put, just a couple of pages in smaller than legal typeface, but You had a 25-page limit, and I think you wanted to get it in there. I got it.
Actually, we didn't,
Really?
They didn't factor in it.
Okay, I'm being snarky. It just looked like small typeface. But it was helpful because I needed all that information. It was efficiently put forth. All right, so I'll be thinking about that as we proceed.